Okay, starting the stream in 3, 2, 1, live. Hello everyone, I'm Leonard French, your favorite copyright attorney. Good morning, good Sunday morning, good afternoon, and I don't think any of you are into tomorrow yet, but if you are, happy Monday morning to you. It certainly will be sometime soon for some of you. First, let me check the audio. Can everyone hear me? Is my lip synced to my voice and everything the way it's supposed to be? No audio. Thank you very much for that. I hope there is audio because all of my bars are going on my end. Try and maybe unmute yourself if you really can't hear it. Thank you, Don Elson. Thank you. Oh, good. The notifications went out on time. I don't seem to be having any streaming issues. Audio is synced. Yay! The blue-eyed gamer Wingnut says 30 minutes until tomorrow. How does that work? It's 10 a.m. here, so you must be an extra half hour off.
He must be in India, actually.
That's very possible. It's just very interesting when, like, it's not just an hour that's synced, that's off. All right, audio is great. 2 a.m. in the east coast of New Zealand. Oh, very nice. Excellent. So it is tomorrow for some of you. Happy tomorrow. Well, hello everyone. I'm Leonard French, your favorite copyright attorney, and we have a special guest today. Brandon, Captain Yosho is with us. Yosho is my assistant. Say hi, Captain.
Hi, Captain.
Can you guys hear Brandon? Maybe he'll say a few things and help. You guys can let me know if you can hear him okay.
Yeah, we were having some
What's the
audio
topic
issues
today?
On Patreon, on the Patreon stream, so.
Yeah, which very, very grateful to the patrons. They were helping me get that all sorted out. What's the topic today? Well, the topic, as usual, is just this week in law kind of thing. No, I don't mean to use Leo Laporte's trademark there. That's just a series of words that came out of my mouth. It's more of like a this week's review of law. Yeah, that's what we'll call it. No, we'll figure out a name for it at some point. Good. Everyone says they can hear Brandon when he speaks. Greetings, Professor Sherlock French. Thank you very much, Pariah Wolfen. Good morning. Greetings to you, too. Fetching haberdashery. We can hear Yoshi barely. Yeah, he speaks a little low, too, so I have to get him to speak into his microphone, but we'll get that all sorted out. There really isn't any one topic for today, so I thought, I would take your questions. So anyone who has questions, please submit them to chat. Brandon will be watching chat for your questions, and I believe, Brandon, you might be able to put a link to an actual question form that we have, right?
Yeah, we have a form set up for you to ask questions. It goes into a spreadsheet. It's really easy for me to access those questions. So if you submit using that, I'm working on getting the link for you. You'll be able to submit them, and we'll get them right away.
Cool. Couple quick questions already. What's my opinion of Trump pardoning Arpaio of contempt of court? I think it's an affront to the justice system, but other than that, I'm going to stay away from it because it's a very highly politicized thing, and this Sunday morning show is not about highly politicized, hyperbolic, extreme things. We're going to be talking about a little bit, we're going to simmer down a little bit for the Sunday show. So maybe I'll talk about the Arpaio thing at some point. It does touch on a bunch of cool and weird issues of law. Can Trump even pardon Arpaio? I don't know. What I'm going to try to avoid talking about is how I feel about it. Like, is it a good thing or a bad thing? From a legal standpoint, I think it is a very weird either attack or affront to the justice system, because look at all the work that these people went through to properly adjudicate this case, and then all it has to do is be pardoned. So it's depending upon your perspective, whether that's right or wrong is one thing. It is definitely some kind of resetting something in the judicial system, and if you want to, we'll take a look at why that's there and what it's there for. So who knows, maybe there will be a legal challenge as well in the opposite direction, and we'll get to see how far the president's pardon powers go. So interesting there. Has the Sargon snafu gotten anywhere? I don't think so. I think it just happened. Literally, we broke the news on Friday. Nothing that, as far as I know, has happened since Friday. So, no idea on the Sargon thing. What we do have an update in is the John Oliver Bill Murray case. Bill Murray? No. Ha! Murray Energy! Murray Energy case. It's Bob Murray, by the way. Leonard, it's Bob Murray, not Bill Murray. Bob Murray, Murray Energy and John Oliver case. We do have an update in that case. So let's maybe turn the music down a little bit, and we'll talk about that. Okay, I can barely hear the music, so hopefully you can barely hear the music now too. Let me know if it is annoying in any way. So how are we doing? Okay, Trump. Chat seems to be okay. No one is upset about anything not working. Great. Okay, so here we are. All these coal companies and Bob Murray plaintiffs versus John Oliver. We've seen this before, but what are we looking at? This is the United States District Court for the Northern District of West Virginia in Wheeling. I'll remark yet again that I am astounded that West Virginia has enough court cases that it needs 2 districts, a northern and a southern, yet we are, what, into August here, and this is only the 99th case that was filed in the Northern District of West Virginia. Son of the Cakes, $2, says, what are those light tubes behind me? Oh, those are WS2812 individually programmable or addressable LEDs driven by Paul Stoffridgen's Teensy. Teensy 3.2, or no, that one actually might be a Teensy LC on a Octo WS2811 breakout board that he has to convert them to nice connectors using RJ45 connectors. So if you put all of those things together, and you can go to pjrc.org, I think, or just search for Paul Stoffridgen, S-T-O Stoffredgens, S-T-O-O-F-F-R-E. Yeah, just search for that, and you'll find all that, and you can program your own. Jared Mulconry, a $5 donation. Thank you for making the subject of law interesting. Keep up the fine work. Appreciate it. Thank you very much, Jared. So this is the federal court order sending the case back to the state level. Now, I don't know why. I have not read this yet. But here's how the procedure works. In state court, if suddenly one of the parties believes that they're hitting a federal issue and they need to have a federal court review the case, they will make a motion to remove or file a notice of removal. And as soon as that notice hits the docket, that notice means the case is now going to federal court. So that's what happened. HBO and John Oliver and the other defendants removed the case to federal court, making the argument that this is all covered under First Amendment, various other free speech or federal law doctrines, and now I'm guessing the judge disagreed. Don Elson, $5. Thank you very much. If I remember correctly, the original filing was more of a press release. Has that been amended? You know, I can take a look real quick. I still have it up here on my screen. I can't bring it up on your screen because, for whatever reason, OBS can't latch into the browser page. The amended... The notice of removal was filed by HBO. They asked for Bob Murray immediately asked to remand it back to state court. So we'll read through this and we'll see what has happened. Yes, the original state court filing does read more like a press release, so we'll see what happens there. And we'll see if Tactical Bra is right about it being sent back to state court is for a jurisdictional issue. So, currently pending before this court is plaintiff's motion to remand. Murray Energy's motion to remand, filed July 7th. Defendants responded July 21st, and plaintiffs replied on July 28th. For the reasons that follow, plaintiff's motion is granted. This case was originally filed in the Circuit County Court of Marshall County, West Virginia on June 22nd. In the complaint, plaintiffs alleged defamation stemming from a June 18th broadcast of Last Week Tonight with John Oliver, which is hosted by John Oliver and broadcast weekly by Homebox Office. On June 30th, defendants removed this case to this court, asserting diversity jurisdiction. Plaintiffs timely filed the pending motion to remand. Plaintiffs allege that following statements made by defendants were defamatory in nature. Defendants asserted that Mr. Murray has no evidence to support his statements that an earthquake caused the Crandall Canyon mine collapse, which took the lives of 9 employees after plaintiffs provided information which claimed an earthquake did cause the collapse, implying that Mr. Murray had lied, the Crandall Canyon statement. Next, plaintiffs allege that defendants insinuated that plaintiffs disregard the well-being of their employees by stating during the broadcast that plaintiffs appear to be on the same side as Black Lung, and that plaintiffs' position on a coal dust regulation was the equivalent of rooting for bees to kill a child, the Black Lung statement. Finally, defendants described Mr. Murray as looking like a geriatric Dr. Evil, the geriatric Dr. Evil statement. Applicable law. We begin with the ungirding principle that federal courts, unlike most state courts, are courts of limited jurisdiction created by Congress with specific jurisdictional requirements and limitations. Accordingly, a party seeking to adjudicate a matter in federal court must allege and, when challenged, must demonstrate the federal court's jurisdiction over the matter. If a plaintiff files suit in state court and the defendant seeks to adjudicate the matter in federal court through removal, it is the defendant who carries the burden of alleging his notice of removal and, if challenged, demonstrating the court's jurisdiction over the matter. Federal courts are obliged to construe removal jurisdiction strictly because of the significant federalism concerns implicated, and that if federal jurisdiction is doubtful, a remand to state court is necessary. There was a lot in that sentence, so let's pause there for a moment. We're looking at this sentence here. Federal courts are obliged to construe removal jurisdiction strictly. So that means that when there's a state court case and a defendant or other party files a notice of removal, that changes the jurisdiction from the state court to the federal court. So the courts are obligated, they have to check to see if the jurisdiction is correct when there is removal from state court to federal court. Strictly means we don't have any leeway. We don't say, well, this time we'll allow it because it would be easier. No, no, no. Strictly means strictly. It means like zero tolerance almost. Because of the significant federalism concerns implicated. Federalism is this weird concept that we live in a country of unified states. The states have rights. The states have power. The states have sovereignty. And they have only agreed to be united under a federal government. The federal government has limited authority compared to the unlimited authority of the states. But wait a second, we're always talking about the states are pissed off that the federal government has too much authority. Well, yes, those are the federalism concerns implicated. Is the federal government taking away too much power of the state if the court system can just hear the state court issues willy-nilly with no other basis? So that's what they're concerned about. And so the check is, if federal jurisdiction is doubtful, a remand to state court is necessary. If it is at all doubtful, you go back to state court by necessity, not by discretion. The court does not have discretion. So, continuing. Citing a Shamrock Oil case, Due regard for the rightful independence of state governments, which should actuate federal courts, requires that they scrupulously confine their own jurisdiction to the precise limits which the statute has defined. Defendants seeking removal bear the burden of demonstrating that jurisdiction is proper, while a defendant filing a notice of removal under the law need only allege federal jurisdiction in a short plain statement. The removing party bears the burden of demonstrating that removal jurisdiction is proper. The court is saying that you only have to file a short statement, a short written statement, in order to get the case removed, but then you also have to back that up with the actual demonstration of removal jurisdiction. Discussion. In their memorandum in support of their motion to remand, plaintiffs argue that defamation of Mr. Murray is sufficient to defame the Marshall County Coal Company, etc., the plaintiffs, if the defamation reflects discredit on the corporation's conduct. Plaintiffs further assert that each of the plaintiff corporations belongs to the larger Murray Energy Corporation. As Murray Energy was allegedly defamed, plaintiffs claim that each of the plaintiff corporations may also claim to have been individually defamed. Plaintiffs also move this court for an award of attorney's fees. In response, defendants claim to the plaintiff corporations that they are fraudulently joined, that the fraudulent joinder doctrine should apply equally to both plaintiffs and defendants, that the common defense doctrine does not preclude removal, and that the statements were not of and concerning the plaintiff corporations. Defendants also assert that plaintiffs are not entitled to attorney's fees. Typically, diversity jurisdiction is determined from the face of the plaintiff's well-pled complaint. An exception to this well-pled complaint rule is the doctrine of fraudulent joinder. In the context of diversity jurisdiction, and remember diversity jurisdiction is when we have an amount of money in controversy exceeding $75,000, and that number does change from time to time, and the plaintiff parties are from different states. So this is the way that we have federal jurisdiction over states, is if the parties are from different states, all parties are from different states, and we have an amount in controversy over $75,000. I'm pretty sure we have an amount in controversy over $75,000 here. The question now becomes, is the separate state requirement met? In the context of diversity jurisdiction, this exception to the well-pled complaint rule allows a court to disregard the citizenship of certain parties. In asserting fraudulent joinder, a defendant seeking removal argues that other defendants were improperly joined because there is either no possible successful cause of action against those defendants, or the complaint pled fraudulent facts. In elaborating upon these requirements, the Ashworth Court stated that the burden of demonstrating fraudulent joinder is heavy. The defendants must show that plaintiff cannot establish a claim against the non-diverse defendant, the defendant who's not from a separate state, even after resolving all issues of fact and law in the plaintiff's favor. Moreover, a claim need not ultimately succeed to defeat removal, only a possibility of a right to relief need be asserted. The standard is even more favorable to the plaintiff than the standard for ruling on a motion to dismiss, and indeed, if the plaintiff demonstrates even a glimmer of hope for relief, the jurisdictional inquiry must end. Nonetheless, a finding of fraudulent joinder is warranted when the record before the court demonstrates either that no cause of action is stated against the non-diverse defendant, or in fact no cause of action exists. In other words, a joinder is fraudulent if there is no real intention to get a joint judgment, and there is no colorable ground for so claiming. Finally, the Fourth Circuit has held in the context of fraudulent joinder that the court is not bound by the allegations of the other pleadings, but may instead consider the entire record and determine the basis of joinder by any means available. Here, there are no allegations of outright fraud in the pleading of jurisdictional facts, thus, the court's inquiry is limited to whether the plaintiff conceivably may state a claim against defendant based on the allegations of his complaint. So we're on a standard that is even more favorable than a motion to dismiss. Remember, A motion to dismiss is what happens when a plaintiff files a complaint and the defendant thinks that they have no cause of action or no jurisdiction or one of a number of other factors in Federal Rule of Civil Procedure 12B, I think it is. A motion to dismiss, the judge automatically finds all facts in favor of the non-moving party. any equivocating, ambiguous, vague facts would be found in favor of the plaintiff and against the motion to dismiss. This is an even more favorable standard than that. If there is literally any colorable claim against the defendant, it goes back to state court. So, where a defamatory statement is made about an executive of a business in his professional capacity, especially in a business setting, such a statement may be seen as defaming that executive's business if the statement would negatively implicate the business or the manner of the business operation. Citing two cases. Such a standard may be extended to lower-level employees of a business where there is a clear implication that the defamatory statement about the employee's behavior would reflect negatively on the operation of the business. However, where the interrelationship of an executive and his business is so strong that they may not be separated in the mind of a reasonable person, there exists a presumption that defamatory statements that would damage the reputation of the executive in his business capacity would also damage the reputation of the business. The rule has not been greatly expounded upon in the states of the Union, but where it has been discussed, courts have viewed it as a basic tenet of defamation. A basic tenet? Could we please stop doing this? The word is tenet. T-E-N-E-T. Often treating the rule as a foregone conclusion and mentioning it in passing. These mentions date at least to the mid-19th century, when discussions about corporations in the courts were in their early stages, as demonstrated by Trenton Mutual Life and Fire in 1852. Therefore, this court finds this rule to be appropriate. The plaintiff corporations in question were, therefore, properly joined, and the case should be remanded to state court. First, Mr. Murray is the CEO and director of each of plaintiff corporations. Not only is he heavily interrelated with these corporations in a formal sense, but a reasonable person who knows Mr. Murray, especially in West Virginia, would find it nearly impossible to separate Mr. Murray from his corporations and mines. With such a strong interrelationship between Mr. Murray and the plaintiff corporations, the defamatory statements made about Mr. Murray in his professional capacity may be easily seen as negatively implicating the operation of his corporations. The allegedly defamatory statements about Mr. Murray did refer to him in his professional capacity. The Crandall Canyon statement refers to a collapse in a mine Mr. Murray chaired and operated. The Black Lung statement refers to Mr. Murray in his professional capacity because his decisions regarding black lung regulation would be made as the chairman and operator of the mines. These alleged character assassinations of Mr. Murray, including the geriatric Dr. Evil statement, refer to Mr. Murray in his capacity as a private individual because they bear no relation to his professional conduct. For those who might not be familiar, Dr. Evil, whose real name is Douglas Evil Powers, gained notoriety as the villain of the Austin Powers film franchise. He is a parody of Ernst Stavro Blofeld, a nemesis of James Bond. Along with his cat, Mr. Bigglesworth, a colorful supporting entourage, and a plethora of secret lairs, Dr. Evil made several attempts at taking over the world before ultimately finding redemption by the end of the final film. However, because of the interrelationship between Mr. Murray and the plaintiff corporations is so strong, it is possible that those comments may defame the corporations if it was determined that those comments discredited the way the plaintiff corporations were operated. The Crandall Canyon statement implies that plaintiff corporations were run by a dishonest figure, while the Black Lung statement implies a lack of care for the safety of Mr. Murray's employees. Even without the character statements, there would be sufficient cause for plaintiff corporations to have a possible chance of success in a defamation action based on comments made about Mr. Murray. Pursuant to the law, the district courts shall have original jurisdiction where the amount in controversy exceeds $75,000 and the matter is between citizens of different states. there is no dispute that the amount in controversy in the instant action meets the required $75,000.01. However, if the plaintiff corporations were properly joined, there is no diversity between the parties because both plaintiff corporations and Home Box Office Inc. are Delaware corporations. Ah, there it is, people. That is the bombshell. I missed that in the original reading. They are both formed in Delaware, and if that's the case, they do not have diversity jurisdiction. For anyone just joining us, this is the Bill Murray, Murray Energy versus John Oliver case. No one has lost the case yet. This is not even close to a loss. However, this positioning that's been going on, where the case was in state court and then got removed to federal court by HBO, well, HBO just lost that. HBO and Murray Energy are going to be trying this defamation case in West Virginia State Court until something else happens, I guess. Defendant's Go ahead.
No, it's okay. Go ahead.
Defendant's primary contention is that the plaintiff corporations were not properly joined because the defamatory statements were not of and concerning the corporations, giving the corporations no possibility of asserting a right to relief. As discussed herein, this court finds that defamatory statements made about an executive of a business may be sufficient to defame his business, where the statement was made about the individual in his professional capacity and reflects negatively upon the operation of his business. Yes, I keep saying Bill Murray, don't I?
That's wonderful. Don't even worry.
Yes, Bob Murray, Murray Energy. Therefore, plaintiff corporations may have been defamed by statements about Bob Murray, giving them a possibility of success in this action as set forth by Ashworth. Because the plaintiff corporations have this possibility of success, they were properly joined. The joinder destroys that jurisdiction, diversity jurisdiction, which would have allowed a removal to this court because the plaintiff corporations and Home Box Office are all incorporated in Delaware. Therefore, this action should be remanded to state court. And then they go over the standard a little bit more. That I think we've already gone over that. Plaintiffs have further requested reimbursement of fees and costs. The Supreme Court of the United States held that courts may award attorneys' fees where a party lacked an objectively reasonable basis for seeking removal. However, defendants in the instant action did have an objectively reasonable basis for seeking removal. Because of the scarcity of case law regarding defamation of an executive also defaming her business, it was reasonable for defendants to argue that this rule should not apply and that joinder was fraudulent. So, no costs and fees. As a final matter, plaintiff's motion for a preliminary injunction and motion for temporary restraining order is hereby denied as moot. This court passes no judgment as to the merits of either motion, but notes that both contain questions of law suited for state court. Based on the foregoing, this court grants plaintiff's motion to remand. The action is hereby remanded to the Circuit Court of Marshall County, West Virginia. As a final matter, the case is hereby ordered stricken from the active docket of this court. It is so ordered. The clerk is directed to transmit copies of this order to counsel of record herein and to the clerk of the Circuit Court of Marshall County, West Virginia, dated August 10th, 2 weeks ago. So wow, what do you think of that? So we're gonna have a battle in state court in the Murray Energy case.
That's very interesting.
This doesn't mean that the judge has any statement or ruling on the merits of the case or believes that the plaintiffs will win in any way. The judge has to open their mind and try to feel it out. Does the plaintiff have a claim at all that should be adjudicated by a jury or a judge in the state level? And that's what the judge is saying here, that whatever this defamation is, if there's defamation, it belongs at the state level here. If it can't be proven, great. But if it can be proven, then it would be proper to adjudicate it at the state level. So that's what we're talking about it. Yeah, so, wow.
A small win for Murray Energy there.
Yeah, sort of. I mean, they got it into their home jurisdiction. It always sort of was, because this federal court was still a court in the Northern District of West Virginia, physically located in Wheeling. I renew my objection to West Virginia having 2 districts, but okay.
People were complaining that the Douglas Powers was a spoiler for the Austin Powers movies.
Okay.
Because
you know those movies came out 20 years ago, right? I'm pretty sure it's Hey. Let me spoil Citizen Kane for you. It was his sled.
Ooh.
Sorry. I just saved you 3.5 hours of your life.
Wonderful.
I'm sorry, it was a really good movie, but attention spans. I mean, you guys are complaining about attention spans for regular 2-hour movies or 3-hour movies. The Citizen Kane's like 3.5 hours long.
Come on, if somebody can watch a 2.5-hour Leonard French live stream, they can watch Citizen Kane, right?
Even I didn't get through Citizen Kane.
Yeah.
Sid the Vicious, thank you for the Canadian $5. Damn it, gonna miss the rest of this stream. Thanks for turning boring lawyer speak into fun and educational thing as usual. Really appreciate it. Unsubbed.
People are flipping out.
You monster, I haven't seen Citizen Kane yet.
Oh my god.
Not the sled!
Oh my lord.
There was no way anyone could have even heard him say Rosebud because he was there alone. Have you heard about what's going on in the Games Workshop lawsuit? Yes! We have a Games Workshop lawsuit update for you. And if you'll give me one moment, I will put it on the screen.
Just so you guys know, while I'm waiting for Leonard here, we are still accepting questions by form. I'll put the link in the chat again, but keep submitting your questions. I'm collecting them here, and I'm gonna send them over to Leonard.
So here's the Games Workshop update on screen. There is no Games Workshop update yet. Sorry, I checked this morning. They still have the summons for the case. I think the thing was filed in May, the end of May. And the way federal court cases work, when you file a court case, you can get the summons right away. And the summons and the complaint have to go to the defendant. And they have to go to the defendant in a procedure that must be followed that's called service of process. And so the process is this process of giving them the complaint. And the service is the actual giving it. And so we call it service of process for some weird archaic reason. And that hasn't happened yet. They have the summons, the plaintiff has the summons, and they have not delivered it. Or at least if they have delivered it to Games Workshop, it's been delivered privately, and the public part of having delivered that has not been put on the docket. That's called a notice of service or a return of service, and that hasn't been put on the docket yet, so we have no news in the Games Workshop case. Yes, Brandon, I guess we can do some questions if you'd like. I don't really have any huge agenda today, nor do I like to make these shows on Sunday morning, you know, hours and hours and hours long. So...
yeah, I have lots of questions for you.
Great, let's go.
Question from Domino X. Any updates you can share on the Alex Maurer case?
Yes, there will be an amended complaint filed probably this week, and it will contain some additional allegations. I'll be accusing her of copyright infringement, interference with contract, and I'll flesh out the allegations of extortion or fraud or coercion or blackmail, however all that plays out. One of those will be in there as a state law claim. I'll also sort out whether we're in Pennsylvania state law or whether we're under Washington state law. So, because I I think it was Washington or Oregon. I think it was Washington that the contract was signed in. So we might actually be in Pennsylvania state court having jurisdiction, but the contract claims may be adjudicated under Washington state law, which the Pennsylvania court can do. But I have to properly plead them in my complaint. So that will probably all be updated this week. And I'll be notifying the judge of the defendant's failure to get a lawyer as far as I've been notified. Could I turn up Brandon's volume? Brandon, I'm going to try to turn up your volume a little bit more.
Okie dokie.
Put you back to 150 and see what happens.
Well, I can cross another question off the list here because you just answered it. Another question from Valdemar. Was there ever an update to the purple mattress case? I've been out of the loop for some time.
There probably is an update to the purple mattress case. I haven't looked at it in a little while, so I'm going to put that on the list of videos to do an update on probably this week, so expect a purple mattress update video this week. I know there's been a lot of attention around that one, so I'm going to do a part 2 on that one, I guess. So thank you. So I don't know what the update is on that then.
Sweet. What do you think about that case anyway? What do you think's going on there now?
Oh, I really don't know. I'm going to need to see the testimony and the facts and all that, and they're probably in the middle of that right now, unless they've somehow settled it. I guess while you're asking me the next question, I'll go take a look at that case docket and see if there's anything I can easily give an update on. It's certainly not going to kill my story, but to
sure.
To give an update now.
Question from Mike Spam. Are there any pardons that aren't an attack on the judiciary? Isn't that supposed to be one of the executive's checks?
It is supposed to be one of the executive's checks, which is why it's not entirely, it's not a bad thing to pardon someone, but usually it's done for very meritorious reasons, and depending upon your political persuasion, you may disagree that Sheriff Arpaio was convicted unmeritoriously, or that his sentence was unmeritoriously long. The times where I've seen a pardon used that I felt it was proper were for, life sentences for your third possession of marijuana charge. We're not talking about violent criminals, but under some state laws, if you were convicted of possessing marijuana a third time under certain circumstances, you were given a life sentence. So that's more what a pardon was for. Not that the person didn't serve, I think it was 9 or 20 years of their life sentence for possession of marijuana. But the pardon was to get them out so that they could, have a more fair sentence. From what I understand, the conviction of Sheriff Arpaio was a little more meritorious than that. So, is the pardon power being used properly, is the question. Not that the president doesn't have the pardon power, but is it being used properly, and what does it mean when the president uses the power in this way? Is it sending a message that that people who do things that Sheriff Arpaio has done, that's okay? So those are things that I think are all valid discussions to have. I'm not going to have them right now on this stream.
Right.
Anything? Okay, go ahead with your next question.
Okie dokie. Question from Rufus. Have there been any interesting movements in the Zootopia case?
No, there was an amended complaint that fleshed out some more of the allegations, and that's the last thing I saw. I'll have to check on an update of that one. Let's see, there is something in Purple Mattress. There's a whole lot of in Purple Mattress. This is the other problem with Purple Mattress. We are at 166 docket entries.
Oh, they are furiously fighting then, right?
Let's see, motion transfer venue. Okay, hang on. Yeah, they are definitely fighting vehemently. There are more attorneys being entered into the case. Let's just look for the word granted. Okay, so yeah, there's been a bunch of going back and forth, and I'm really gonna have to look into this because I have no idea what's going on. At first glance, they look like they are just going tooth and nail in litigation here.
Yeah, that's fair. It sounds like it's going to need its own video to kind of work it out.
Yeah.
157,
157, motion to reconsider transfer of venue at 151. Okay, no, that's a memorandum. It's a general memo. Okay, so I got to read the whole thing basically to figure out what's going on here. So no, there's no update in Purple Mattress yet. It is still going strong. Any update in the Steel copyright troll case? Yes, he pled guilty, and so he's going to jail and has to pay back his defendants. For anyone listening who was looking into was having me look into that for them, I'm still working on that. I need to contact the appropriate authorities, and it has been one heck of a weird summer. So I will be getting on that shortly too.
But we do have a video about the
yes, there are several videos about that.
Yeah, the results of that case. There's a whole video about it, and there's also a bunch of videos about the proceedings of that case. So
nothing is going to move quickly on that, but hopefully people will be able to get their money back. Go ahead, Brandon, with more questions.
I have one about Murray. What does Murray get from going to state court over federal court?
Well, first, the case has to be in the proper courts. So really, it belongs in state court anyway, if that's the case. But in state county court, you can almost some attorney. I'll put it this way. I'll put it nicely. Some attorneys and some people will assume that a state court judge will be more favorable to the party that is involved with the state. So Murray Energy is obviously heavily involved with the state, so you can imagine that some people think that a judge will, in the back of their mind, go, well, however I'm going to rule in this case, I don't want to screw around with the business people, the good business people of West Virginia, so maybe I'll just give them a little bit of leeway, a little bit more than the other party. So maybe you could hope that the one party would get a little bit of leeway from the judge that the other party wouldn't. That's called bias. It's not supposed to be there, and it does happen in real life, but it doesn't always happen where you might predict it to happen. Maybe you can predict it to happen on juries, but you might not be able to predict it to happen with judges. So there are people out there who study these sorts of things and make recommendations and advise lawyers about individual judges or juries or things like that. So I would expect Bob Murray, got it right, to be trying to take advantage of that any way he can. And I would expect the judge to be trying to clear any air of bias that might be present. So the judge should be acting very much in an unbiased way and trying to make sure no one is able to allege that the judge acted in any sort of improper way. Disney is an example of how the law favors the rich. Well, not a question. I saw that and I wanted to repeat that here. Sort of. The law, and including Disney, do people, rich people or people who are wealthy or people who are willing to pay for legal defense or legal offense, or in Disney's case, a legal policy, what's the word, going to Congress and... you know what I'm talking about. I've lost the word. My words have failed me. Anyway, Disney and wealthy entities who are willing to pay for it benefit unfairly because those are just the barriers to entry of the legal system, and there is nothing that says a poor person is entitled to legal representation in all areas of law. Only in criminal defense is a poor person entitled to a free defense. And even then, they're entitled to a free defense by a lawyer with limited resources acting as a public defender and getting paid around $35,000 to $45,000 a year. Yes, you heard me right. A public defender in the United States gets paid around $35,000 to $45,000 a year. So you are not talking about wealthy people defending poor people. You're talking about poor people defending poor people. And somewhere in there you can start to see that there would be some kind of mismatch. The government has near unlimited resources to investigate a crime, but those same resources aren't matched in most cases to the public defender's office. So unless you have the money to pay a lawyer to do your full-on offense or defense or policy making or whatever, you are at a disadvantage to those people who do have those resources. This is the access to justice question, and we are constantly talking about it as lawyers. And individually, no one knows what to do. We have to come together and figure something out. But then if you start to put together a pool of money and you start to require people to pay into a pool of money, and then it pays out to the poorest, from each according to their abilities, to each according to their needs, well, shit, isn't that Marxism and communism and socialism now? And isn't there an entire political movement that's going to be against you? So none of these questions are easy questions to answer. Sorry for the rant.
I think people are here to listen to you rant. So
that's fine. I'm happy to rant. I've got to stop myself sometimes before I get to into politics. Next question.
What kind of relatives from Cecil? Sorry, I didn't read the last sender. What kind of relative power will the precedent set by the H3H3 case have in future fair use cases?
I don't know that the H3H3 case actually set a precedent so much as it was a historical case and a very good summary of existing law. And so I'm not disagreeing with you. I'm sure the way you meant the word, it's very precedential. And the way I mean the word is just that it's not a legally binding precedent. It's certainly a citable case, and it's certainly legally binding, but it's not precedential because it didn't really make any new law. It just applied the existing law the same way it's always been applied, and it applied it to a new situation. So in that sense, it's precedential as it dealt with new media, but it is not precedential as in it created new law. So I'm calling it historical, and I think it is very binding. I think it is 100% binding. I think the law that it cited was all very good law. The case itself should be citable within the Second Circuit, should be citable within all the circuits as persuasive law, non-binding against the other circuits, but still very good summary. However, if you're in, say, the Ninth Circuit and someone sends you a brief with all Second Circuit cases, you're going to be a little bit ticked off because you need to cite your opinion, your judge's opinion, in Ninth Circuit cases. So you're not going to be citing Second Circuit cases as your main source of law. You're going to be citing Ninth Circuit cases. So the important point is that all those cases and all of that law is good law. The analysis is good. It should be the very same law that applies to all 50 states and around the world to anyone doing business with YouTube in the US, because US law applies. And so, yes, it's a very strong case for fair use and YouTube. And other new media, uses of new media. So in that sense, yes, it's very precedential and historical and important in that sense, yes.
Okay, question from Chloe. There has been some discussion on the Discord about whether Sargon and Aquila share a market since they target different audiences. Could you please break down why they might or might not share a market?
I believe you're talking about the usurpation of the market that I keep talking about in one of the fair use factors. No, they don't need to share the same market. The question is whether Sargon's video overlaps the Aquila's market for her video in such a way that it usurps it. And this fair use factor might not be the strongest fair use factor. It might not really go in either direction in the Sargon case. He was posting it probably as some sort of response to her political message or her political whatever. Was he doing it to usurp the market? Did it have the effect of usurping the market? Were people watching his video instead of watching her video? Probably not. I'm sure that the judge and everyone's going to hear the arguments back and forth, but I would expect that fair use factor really wouldn't be the factor that determines the case. It's probably going to be the first factor, the transformation, whether it was transformative or not. If it was not transformative, then it's just copying, and that's kind of automatically not a fair use. So I'm not ruling one way or the other right now. I haven't even seen both videos, but if the fourth factor, or if the usurpation factor is not the factor that really goes one way or the other, then we have to look at the other three. John Cripps, thank you for the £10. Thank you for all your work making law fun to learn. I really appreciate that. That was my backup battery for the microphone. Thank you. Very, very much appreciated, John Cripps. All right, Brandon, next question. How are we doing?
Lots of the questions are rehashing stuff that you've answered already. Here's one from Techno Pop Tart, which is an awesome name. Why do many places in the United States require persons who want to change their name to publicly post their old and new name in the local newspaper?
It's a notification requirement. Nowadays, it would be easier to think of it that way because it would be searchable, and if you searched for the old name, you'd then find a notice somewhere, not necessarily, on the first page of Google, but you'd find somewhere a article about, a very short article, but a very short article saying, so-and-so changed their name from John Doe to John Doe 2 or Jane Doe or whatever. So that's why it's done, is so that there's notice. Why it's done in the paper is that the newspaper used to be something that everybody read, and you could count on the town all reading the newspaper, and if anybody wanted to know what notices of cases or judgments or bankruptcies or property that was being sold, etc., it was always in the newspaper. There was no internet. It wasn't printed in books. There were no screens. It was always printed in the newspaper. So that was the go-to place for information back in the day. So that's why it was considered the correct thing to do for notification. Will that get updated? Yeah, maybe it'll get updated. The internet's only 30 years old? I mean, I know the internet's older than that, but I mean the popular internet has only been around since about 1994 or 5 in its sort of currently recognizable form. So we're only talking about 1.5 human generations. These laws are going to take probably another several generations to get updated. And until then, there will be interpretations. Judges will interpret, well, notification in the newspaper now means notification on the newspaper's website. So something like that. So, or maybe notification on the court's website, since the courts are now basically, they can publish their own things even more than the old newspapers could.
Alrighty. Question from Zeno. 30-second explanation of what different circuits are for non-Americans.
Oh, this is a great one. I like this question. Excuse me. In the United States, you have 13 circuits, which are the appellate court circuits. I don't have a graphic to put up on the screen, but at the very bottom, you have the state courts, and even below them, you have like the state's municipal courts, or small claims courts, or magistrate courts. Then you have the state county courts. Then you have the state appeals courts. Then you have the state Supreme Court, or state highest level court. I gotta not say Supreme Court because the New York Supreme Court's actually the lowest New York court. But you have the state top court. Then you have the lowest level federal courts, the federal district courts. Then you have 13 appellate districts or circuits. You would normally think of them as regions, and so you have the Circuit 1 is like Maine and New Hampshire and Vermont, and Circuit 2 is like New York, New Jersey, Connecticut. I might butcher these a little bit. Circuit 3 is like Pennsylvania, Maryland, and a few others. Ninth Circuit, for example, is California and Washington and Oregon. Fifth Circuit is Chicago and Illinois, I think. There's a map. You can look up a map. But we don't call them regions. We don't call them districts. We call them circuits. Why do we call them circuit? What the heck is a circuit? A circuit is like a beginning-to-end loop. What the heck is a beginning-to-end loop as it comes to do with a judge or a court case? Well, remember we were just talking about newspapers and back in the day. Well, we didn't have cars, and we didn't have internet, we didn't have telephone, we didn't have telegraph, but court cases needed to be heard. They needed to be heard in person. So what would happen was an appellate court judge would have a schedule, and they would schedule their cases in West Virginia for 1 month or whatever. They'd schedule their cases in Maryland for another month. They'd schedule their cases in Pennsylvania for another month. They'd schedule their cases in Western Pennsylvania for another month or whatever. And over the course of a few months or a year, they would ride their horse, literally ride, you know, in a horse and buggy or whatever, between the court systems of each state, of each region of each state, and they would ride them in a circuitous fashion. You know, not at one day or whatever, but like, you know, month to month or whatever, they would transfer from court to court. And that was called riding the circuit. And they were then called the First Appellate Circuit and the Second Appellate Circuit and the Third Appellate Circuit. And so that's where you get the circuits from. The judges would literally ride a horse from town to town hearing the cases.
That's interesting. I learned something new today.
Fun, huh? I kind of would have liked to be a circuit court judge back then.
And then a bit of an add-on to that. Why is New York Supreme Court the lowest?
That's just the way they named it. I have no idea why. That would be an interesting history question for someone to answer. That's just why they just named it that way.
Fair enough.
Because New York needs to be different? I don't know.
Well, it used to be the capital used to be in New York. Question from Matthias. What are your thoughts on elected judges versus appointed judges?
That's a good question. That's a devil you know, devil you don't know problem. Elected judges are great. Elected by the people. That can never go wrong, right? We've never seen anywhere in the history of anything where the people elected a bad leader. So, obviously, an elected judge is going to be a great judge. An appointed judge... Appointed by who? Appointed by an elected leader. Like the president, for example. The president can appoint federal district court judges. So, great. So, I mean, that could also work well. You've got a smart, intelligent leader, unbiased leader, looking at the will of all of the people and trying to determine who is the most unbiased person that will not try to further their political agenda to sit on a federal court, bench. I can't see how either of those would go wrong. And if you haven't been able to tell, that it was all sarcasm.
So it's either direct election or election, like one step removed, is what you're saying.
Basically, yeah, that's how it's done almost everywhere. Like even in Pennsylvania here, we have magistrate judges that are elected by the local municipality, the local citizenry of their municipality, and it varies. They're like little fiefdoms, and you can see the different attitudes of citizens in their different elected judges. The citizens of Bethlehem, South Bethlehem, for example, elected Judge Matos Gonzalez, who has zero tolerance for traffic cases. Whereas just about everybody in Lehigh County, only a few miles away, less than 5 miles away, everybody gets a deal. Everybody gets to break a traffic law once in a while. So it's just, they're like little fiefdoms, and every judge is a little bit different.
Question from Erik. In the Murray case, since they've been shown to both be from Delaware, why wouldn't it be removed to Delaware? Or do they have the option to request movement of venue to another state?
Yeah, this is the complicated question of jurisdiction, and so yes, they could have filed the case in Delaware, by just citing that yes, two of the plaintiffs are from Delaware. That would have worked. That fits jurisdiction. There is also jurisdiction in West Virginia as a place where the injury occurred or something like that. I would have to review the complaint, but in the complaint will be an allegation that says the injury occurred in West Virginia, or that HBO and defendants have sufficient minimum contacts with the state of West Virginia. Bob Murray, an energy company, will have to comply with West Virginia's service and jurisdiction laws. And as long as they've done that, then yes, West Virginia will feel like it can hear the case. I'm guessing the biggest basis for jurisdiction in West Virginia is that most of the companies are there and do their coal mining there in West Virginia. So that's where they're physically located, would be the argument that I would expect them to be making. Technical Fool gives £5. I felt the heat from that burn across 3,000 miles of ocean. Thank you.
Actually, that's an interesting question that I have for you. How do you feel about corporations registering in certain states because corporate taxes or laws are different in those states?
On one hand, the Republican conservative in me says, you know, hey, let everybody save money however they can as long as it's within the confines of the law. The problem that creates then is states compete to lower their tax burdens and regulations on corporations so that they will, for instance, incorporate in Delaware in order to get a more favorable tax rate, or incorporate in Georgia to get a more favorable tax rate, or incorporate in Texas to be able to use the Texas patent system, or something like that. So, yeah, I don't like that that's that easy to do, but we're also supposed to be a free country, and if I believe in the freedom for citizens, I should believe in the freedom for corporations. I don't believe in the unlimited freedom for anyone, but I do believe that they should have the freedom to exploit whatever state tax law they want to exploit. I think there should be some minimum set by the federal government, some basic regulation, but not anything overbearing. In order to allow competition, I mean, you can't say zero taxes, right? Like, if a state just said, hey, all the corporations can come here because of zero taxes, and then everybody moves there, everybody else is hurt, the state is still going to be hurt because they really can't support themselves with zero taxes. So everybody loses just because someone was trying to be a little greedy. So I honestly feel like, you know, this is a political statement, that there needs to be moderation. You can't have purely liberal democratic views. You can't have purely communist views. You can't have purely socialist views. You can't have purely Ayn Rand views. You can't have purely Republican views, purely conservative views. You can't have no regulation. You can't have over-regulation. You can't have no health and safety. You can't have required health and safety. There's got to be like an in-between to everything. And that's why this political climate of like hyperbole and bipolarism and fighting over every stupid little thing is not helping anyone. It's bringing us all down as a country. We are losing whatever foothold we did have against the world, and that's not helping us, and it's not helping the world. But I can't get people to stop fighting. You can lead a horse to water, but you can't make it stop drinking. Rant. Sorry.
Question from Liam. Will this question be answered on stream? Yes. Question.
Zuberuber, Polish 25, lobbying. Thank you so much. I forgot the word lobbying. Lobbying exists in the USA. It does seem like legal bribery. I'm not exactly sure how it's legal in that sense. However, lobbying is just going to your congressman and saying, I represent the coal industry, or I represent the free speech industry, or I represent the copyright industry, you know, or these people within it, and we have this position. Would you talk to us for some time? And that's what lobbying is. Is there illegal bribing going on? Possibly. I don't know. I have no proof of it. I'm too far removed from that. Does it seem like there's something illegal going on because it seems too easy for people with more money to get their way than people who have meritorious needs, like the people of Flint, Michigan, who need clean water? Why is this so difficult to get them clean water, and why is it so difficult to hold the people who did it accountable? It just seems like lobbying creates a disparity of wealth. People with wealth can continue to lobby for more favorable laws and rules and regulations, while people who are affected by those laws and rules and regulations, including people who are made more poor by those laws and rules and regulations, are losing their ability to then represent or reach their representative and have the same effect because they don't have the money to give them. Their voice is not as loud. That seems to me an unconstitutional disparity, but I've not been smart enough to be able to make that argument in a successful way, let alone actually file a court case and have it win. So this is what you need. Good people cannot sleep on their rights. You need good, vigilant people to gather their resources, gather their people, gather their money, and put it all together and fight for their rights. Honestly, that's the ACLU. Whether you liked it with the rights, the things that they fight for or not, the ACLU is one of those organizations that seems to be trying to protect the rights of the unprotected people. So I really can't say enough good things about them from my perspective. If Bob Murray wins, can Donald Trump sue the entire planet? No, but if Bill Murray wins, Donald Trump can sue the entire planet.
Oh, Lord.
Are there more questions?
Yeah, there's a few more. Is it possible for a document of some kind to be made to show the progress and standing of cases we're following? Yeah, we could work on that, right?
I think we could work on that. I might make that your job, though.
That's fine. I can do that. You'll have access to it on the shared email, but yeah, we can definitely work on doing that to keep you guys updated and post links in the description of all the videos so you can see. That would probably be very helpful, actually. So.
If Leonard was president, there would be no time for live streams. Are you kidding me? The way President Trump uses Twitter these days, you don't think I'd be on YouTube every day explaining my political agenda?
Question from Gabos. Do you want to be a judge?
It's crossed my mind that maybe later in life, when I'm a little less ornery, maybe I would make a decent judge. I don't know.
Okay.
I like the idea. I think I would be as fair as possible. I recognize my biases, and I think I can keep them in check. So I don't know. It's I like this. I like this. I like my community. Maybe we could turn this into a Judge Judy type of thing, and I'll be your celebrity judge, and not like a actual government judge. We'll see. We'll have the copyright court of lawful masses, and everybody will submit their copyright disputes for binding adjudication by me. Mechanic 87 adds, "We need to remember this. America will never be destroyed from the outside. If we falter and lose our freedoms, it will be because we destroyed ourselves." Attributed to Abraham Lincoln, although I haven't checked it, so. But it sounds like something he would say.
Question from Dreamer Don. Which cases are we currently following? This is actually a really good question.
Oh, let me pull up the list. There's a very long list.
The Judge Judy comment seems to be getting extremely positive feedback in our chat here.
There's a lot. We're going to be talking about the Abbott and Costello lawsuit. We're going to be talking about the malware tech charges. we were going to be covering some Beyonce and Kim Kardashian cases. Games Workshop will be following up on that. Daddy05 will be following up on that. He's going to court on the 1st, I believe. The Reading Rainbow case. Google was sued over the firing of that guy, I think. We went over Bill Browder. I think we went over Bill Browder already. The ad blocker. Oh, yeah, I almost forgot about the ad blocker copyright stuff. That we should do that.
All right.
And more. And more and more.
And more.
Especially as the game Vice versus Nintendo. I also subscribe to a paid news service that gives me copyright news up to the minute. So I try to keep up to date with that. It gives me an alert every day in my browser. So.
And then, of course, we're following the Aquila versus Sargon and Murray versus HBO.
Right.
And Alex Maurer. And all that stuff is still being followed. So.
Lightshield? What's the Abbott and Costello lawsuit? There was a off-Broadway play that used the Abbott and Costello Who's on First routine, and in the process, they lost. They sued the off-Broadway play, I believe, and they were then unable to prove that they had the copyright. And so it turns out that the Abbott and Costello routine, or at least the original version of it, should be off of copyright now. And so I'm going to get my boy Brandon here and I to perform a version of it. Judge Leonard fucking French, son, says Jesse Pinkman. Thank you, Jesse.
Oh, Lord.
Can I do a review of the Richard O'Dwyer case? I will definitely consider it. Let me remind myself which one that was. Was that the protester guy in California or Washington or whatever?
In case you were wondering, PLN is Polish zlotys.
Yep.
Donation from Jesse Pinkman.
Oh, no. Okay, yeah. 2011, Justice Department sought to extradite O'Dwyer from the UK in relation to a website, tvshack.net search engine. It looks like all charges were dropped, but yeah, I will put that on the list. Brandon will be the manager, or I will be, I forget if that was Abbott or Costello doing the,
I'm the manager. I don't remember which.
Yeah, you're the manager. I'm the other guy. When am I coming to Australia? When I can afford it and I can stand 24 hours on a plane.
That was actually one of the questions in the document, but I didn't put it through. Question from Gabos again. If I purchase an island in the middle of nowhere that isn't attached to a country, can I make myself king and legalize murder?
Sort of. There is something called international law, and you would still be violating international law by murdering people. But yes, within the bounds of international law, you would likely be, otherwise lawless and able to create your own, legal framework or whatever. And this is going to be an ongoing problem for humanity, assuming that we survive Spaceship Earth and are able to get into the cosmos. When it takes years to get between planets, those planets effectively have their own governments and their own law. So whoever's in charge gets to do whatever they want. So I guess where I'm going with that is that these problems of humanity, slavery and bias and bigotry and categorizing people as less and another category of people as ruling and oligarchies and aristocracy, these are not problems that are going to go away just because it's 2017 and we should have outgrown them by now. We actually... we have this human condition, and every time a person is born, they don't have these experiences and this knowledge, and it's up to us to put a framework together to educate people with some kind of base level of education so that they can think critically, think for themselves, identify problems with their mind, problems with other people, problems in the world, and attack those problems in the most appropriate and effective ways, while also trying to be a happy individual pursuing life, liberty, family, etc. So, sorry, another rant.
I have a question that I'm going to heavily paraphrase from Pentama. Are copyrights monopolies? People seem to refer to them negatively like economic monopolies.
Correct.
Though they seem more like ownerships, like any other property that can be owned.
Both.
Does copyright only apply to property sold to the public?
No. Copyright applies to any fixed work fixed in a tangible medium of expression. Any minimally creative work fixed in a tangible medium of expression. This video is copyrighted automatically as it's being made. It's not that anyone is in the background going copyright, 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 copyright. It just happens by law, by the effect, the function of the way the law is written. Since it's being fixed as it is being performed, it is copyrighted. So, is a copyright a monopoly? Yes, it is absolutely a legal monopoly, a legally supported monopoly, with the purpose of furthering the sciences and the useful arts, is the way that the U.S. Constitution, Article 1, Section 8 says it. The limited monopoly, I believe it says by granting from time to time limited monopolies or something like that. The reason for granting a monopoly for a limited period of time is to give value to that author's work. And if the value can be made in something that's copyrighted, then the author has an incentive, an economic incentive to create more works. For example, yours truly is creating more works for you because I'm given the right to monetize these videos after I make them and publish them. Yes, you guys are supporting and you're contributing money, and actually you're contributing more money than I'm usually making from the channel, so this is awesome. We've diversified the income, and you know, if there's another adpocalypse or if I get hit by a bus or something, maybe you know, YouTube ad revenue going down won't shut down my channel, but the ad revenue and the YouTube Red revenue and stuff, I get that because I have that limited monopoly on the videos that I make and post, and nobody else can post them and make money off of them legally. And when they do that, I have a legal remedy to go back and get that money or something like that. So, yes, it is absolutely a limited monopoly. Patents are a limited monopoly. Trademarks are a monopoly on the trademark itself, the use of the trademark in commerce. And these are all with the intention or purpose of incentivizing the behavior. We want people to create more copyrighted works. We want people to invent patentable things. We want businesses to brand the source of their goods so people can tell that the product they're getting is coming from the same place and should be of the same quality, and that quality can be attributed to that source. So we want to incentivize those things, and therefore we grant these limited powers for limited periods of time via the Constitution and via international law in order to make more things like that. Make sense?
Yeah, I think so. Solar Paint Dragon says, don't get hit by a bus.
Thank you. I will try not to get hit by a bus.
We had a donation from Brendan Horn saying, hello from Houston. Glad to have something to distract from all this flooding.
Oh, jeez. Yeah, I hope you guys are okay down there. Thank you for... oh, gee, look at the emoticons. That's nice. Yes, Brendan, I hope everybody's okay down there. So when you copy something directly, does that make it a copyright? Well, the reason, I don't know if you're being funny or not, so haha if it's joke. But if you're not being funny, the reason why we call it a copyright is there are literally rights that you are granted, and those rights are related to the copy, which was the word for writing things down. In the olden days, again, the newspaper, you didn't write an article, you wrote copy. So we've bastardized the word copy because to us that just means, you know, making a copy, and that's it. So now, you know, the word doesn't mean the same thing. But yes, the copyrights are the right to copy, the right to perform, the right to control derivative works, the right to control distribution, and there are some moral rights in there, what we call moral rights, as in the right to control, even after you've sold the work, the right to control your, like, the image of the artist, like the characterization of the artist through that work. So somebody can't take that work and then use that work to disparage the artist. They can make critique of the work, but they can't use your work to disparage the artist in certain ways. What's my opinion of the Shopalato case? No idea. What's a Shopalato? Let's find out what the Shopalato case is.
In the meantime, Errorism asks, what do you think is the best representation of law in film or TV?
As far as the Shopalato case, I'm going to have to pass on that one. I'm not familiar enough with it or with patent law to be able to speak about it. But I will put it on the list for my research and get back to you if I feel like it's something I can do. Sorry, go again, Brendan.
From Errorism, what is the best representation of law in film or TV, in your opinion?
My Cousin Vinny's a pretty good one. 12 Angry Men is a pretty good one. More modern, The Lincoln Lawyer is kind of close. I can't speak more authoritatively on modern law shows because since about 2007, I have not watched a single one of them. They become highly annoying when they are not accurate. And even when I know why they're not accurate, because it just makes a better story to cut out some of the stupid stuff, I still don't like it, and it still bothers me, so I don't watch them.
Okay.
Yes, go ahead.
There's a question. I'm not going to read the username. What happens if you violate international law by murdering someone in the country that you founded?
That's a good question. We live in a global economy, so you're not going to be having your own private island without needing some kind of supplies or something like that. You could have international sanctions granted against you, as in you're put on a blacklist and you're not allowed in that country. You're not allowed to receive exports from that country, and you'll have to turn to the black market, and so you'll be doing business with the black market, and good luck, because guess what? The black market is also lawless. So now you basically turn into an arms dealer, or at least someone who's in a bit of an arms race to make sure that they can handle the black market people that they're dealing with. So it's generally not a good idea to piss off the international community that much. That said, I'm more than certain that there are human trafficking problems at the level and worse than you're alluding to, with private islands and things like that. There's more than enough ways for people to still do horrible things to people, and that's probably one of the ways that it's done.
I'm not sure if you remember, but a few months ago we were talking about getting you a knighthood in the country of Zealand.
Oh, yeah. Nice. Yes, well, even Sealand is not recognized by the international community as its own country. He tries to get himself recognized, but like the actual country of Sealand does not exist internationally.
Yeah. Question from Tommy 2 times. Maloney. I had the last part. Why isn't a parent spanking a child guilty of assault?
It's not. If it is corporal punishment, you are allowed to spank a child in many places. A spanking needs to use reasonable force, and reasonable force for a spanking is not very much force at all, because a child is going to feel pain a little bit more than an adult will. The adult needs to not be spanking the child out of anger, but out of a genuine correction, as if you would correct an animal with a slight smack or something like that. Obviously, if you smack the child hard enough to lift them off the ground or throw them across the room or leave a mark or cut into the skin, that's not corporal punishment. That is where it crosses into child abuse. But you are, with an open hand, and you have to check your state law, but in many places you are still allowed to punish your child with a painful smack, as long as it's done with reasonable force and appropriate under the circumstances. Get ready to have Children and Youth Services or whatever organization protects children, or your opposing party in your custody battle try to use it against you. It's not recommended, it's not favored, but it is allowed. Why we did not read that person's name is that that's a misuse of the homosexual reference, and I consider that a slang. Sorry. I do not use that word to mean anything but homosexual. So if you do, that's your prerogative, but I'm not going to repeat it on stream. That's all. No offense. I'm also not criticizing you. I'm just saying that's why it didn't get read. Next.
Questions are kind of running dry a little bit here. You guys should submit some more.
That's fine. We're an hour and a half into the stream.
Yeah.
So
yeah.
I would like to get started on my day. Some of you would like to get started with the ending of your days. And so I'm going to end the stream here. So thank you everyone for joining me. Let me talk about some of my sponsors here and talk about some of our next videos. I am finishing up a video on the basics of copyright for YouTube. And we're going to talk about everything from fair use to the latest H3H3 verdict or opinion. Ninmin58, thank you for the £2. Why does the U.S. grant patents for business methods? I actually think there was a recent ruling where we don't grant patents for business methods too much anymore. At the same time, I am not a patent attorney, so I'm very sorry I can't go any further with that. For the month of August, New Sensei has sponsored that video, The Basics of Copyright for YouTube Creators, and I thank you very much, New Sensei. If anyone else would like to sponsor a video, it's the recommended sponsorship level is $500. I have a bunch of $50 a month supporters, which I'm also very grateful to. Joshua Meinzinger, Baxorn, John Cripps, Nate Beck, John Steele, Westin, Lohne, Lydia Collinson. And my $5 plus supporters are scrolling on my LED panel above me and will be posted in the description below. Malachor5 gives $20 and says, why is jurisdiction so complicated? You said the other day that you think Sargon would argue for dismissal of his case because of jurisdiction. If he's guilty and the case gets dismissed, that seems like a loss of justice. Sort of. Jurisdiction would be somewhere. Somebody has jurisdiction, so the case would have to be filed wherever jurisdiction is proper. If Sargon is able to argue for dismissal because of improper jurisdiction, that just means that the jurisdiction needs to be someplace else and the case needs to be refiled. So not a huge loss of justice, but definitely a barrier to entry. Jurisdiction is so complicated because of the things that we said before about federalism. You have states which have rights and the federal government, which is the unified states under the federal government. The states still have rights. The federal government has authority over them. And so jurisdiction is the complicated intermingling of when does the state or the county have correct jurisdiction versus a different county, a different state, a different court altogether, like a federal court, or something else. So thank you all very much for joining me. Is there anything before I end the stream, Brandon?
One more question. Today
Go
is
ahead.
International Dog Day, so could we please see some dogs?
Oh yes, the dogs! I almost forgot about the dogs. Let me see if I can go get the dogs. You have to wait for a moment. The dogs are outside. I'll be right back. Brandon, see if you can keep everybody entertained for a moment.
So
I'll go get the dogs.
Let's see. Let me read the chat a bit. Yeah, it was a bit long. I'm really sorry I didn't ask the question. It's just, it was about an essay in length, so I'm sorry about that. Yeah, and make sure you guys check out the Patreon page. There's a link in the description. You can contribute to help Leonard keep making videos. He really deserves it, let me tell you. And also, we have a Discord server, so most of the community interaction takes place on that Discord server. So if you just go and click the link, you can join. You do need to have a registered email in order to do that. So, what? I'm trying to entertain them, man.
Yeah.
Yeah. I'll send that question to Leonard, and he will look at it and decide if that's going to be a video. But I appreciate the question, really.
Do you want to PM it to me if you don't want to read it on stream?
Yes, of course.
So this is Nico. Say hi to Nico. He's looking at himself in the corner. Aw, Jack M, $5. Thank you. Leonard French rules everything around me. Get the money. Dollar bill, y'all. He had a bug bite. He had a flea bite on his forehead, even though I do treat him for fleas. And he had an allergic reaction to his flea bite. So I shaved his little head, his little patch around the bite, so that it would be nice and clean, and treated it and everything. He got one on his neck too. He got 2 flea bites, even though he's treated for fleas. I can't imagine how that happened. It was only a topical flea treatment, and we've only been doing all of those dog pool parties in the past month, so they couldn't have anything to do with one another. Oh, I see it, Brendan. That's a very long question. Yes, I will definitely take a look at that, but I can't take a look at that right now.
Yes, of course. We do have a video about Sargon's lawsuit, so if you check that out, that should explain everything about what's going on with that.
Yes, everyone's favorite therapy dog. Ah, yes, that's another thing I can finish up with. Back to the purpose of copyright. Then the expiration of copyright is supposed to promote then the public's benefit, because then when the things expire into the public domain, the public can use them for whatever they want. So the world did not move as fast 100 years ago as it does today, and it certainly didn't move as fast 100 years before that. So the idea behind copyright having an expiration within a number of years is just that the benefit then escheats or returns to the public, and the public can use the information for whatever they want. Aw, thank you, Jack. Extra $2 because Nico is cute. Yeah, I have the webcam turned on over the 7D Mark II.
I see. It looks so strange.
It's much easier for me to move the Logitech camera than it is to move the 7D Mark II.
Fair enough.
I need to get a much stronger, like pistol grip mount or something instead of this desktop tripod. This desktop tripod that I can shake when I shake my desk. The doggo channel is called Such Dogs, SUCHDOGS.
There's actually a panel for it on the channel. If you click on the channel, you can see.
Yeah.
If you scroll down, there is a panel for Such Dogs, and there's a panel for Leonard's gaming channel as well.
Yeah, Jack, that's weird if your donation isn't showing up on the chat on the stream. Stream down? I hope not. I have no errors over here.
So I think the way that YouTube works is it will only put the top. They'll only put certain dollar amount donations on the top bar. And
yes, well, yeah. Certain ones don't go into the top bar, but the $20 one, yeah, that should be there.
Yeah.
Yes, there'd be a little bit of audio lag because I'm using the webcam. If I switch back, to this, it should be synced up now. But it won't be synced up here. I'm going to turn the music up. Steamboat Willie should be in the public domain next year, I think. Or by 2023, I think. I forget which analysis is correct.
Are we doing any Twitch streaming today?
Yeah, there'll probably be some Twitch streaming today. I have some other things to take care of, but do we want to do any Twitch streaming now?
I don't know. Would you like to?
Yeah, let me take 5 minutes to go use the men's room.
I'm gonna do this.
And maybe throw the ball for my dogs in the backyard for a little bit.
Cool. I'll post a link for you guys to the Twitch channel that Leonard has.
This is a very happy dog. Yep, so we have the Discord channel, we have the Twitch channel, we have the Patreon for anyone who wants to, oh yeah, you want to stream some cards? We could stream some cards.
Sure.
Can we limit the cards to only, like, 8 people or something? It seems to get out of hand.
Yes.
Quickly. We'll see what we think about that.
Yeah, guys, check the Discord server in a little bit for the Cards Against Humanity thing. It'll be first come, first serve. I'm going to limit the channel to 8 people, and we're going to play some Cards Against Humanity.
Yep, I'll be back in like 10 minutes then.
Sweet.
So thank you everyone for joining me. Really appreciate you all. Love you all. It's a beautiful Sunday here in Pennsylvania, thanks to all the flooding in Texas. So I'm sorry about that, and I hope you all survive Texas in one piece. Maybe a little bit wetter, but maybe in one piece. So thank you all for joining me. I'm Leonard French, your favorite copyright attorney, and I'll see you on Twitch in a few minutes. Have a good one.
Bye-bye.